We're recording. I apologize for stepping away. Catch my breath from running up and down steps. All right, we're here for the public deliberation in case 21-029 SPH. It's Norman and Ellen Barton for the Overshot Court property. This is a petition for special hearing pursuant to BCZR Section 500.7, which is seeking to remove the condition from a 1990 case number 9183 SPH, that prohibited any future development of what's been identified as Track A as part of an FDP, and to also determine that the property qualifies as an existing lot under BCZR Section 1A 07.8.B.4. This was appealed from an order from the ALJ denying the petition for special hearing that occurred on 10/12/21. So I am here this morning with my esteemed colleagues so we can discuss this matter at length. So with your permission, I'll start talking about some things and then I'll hear from both of you if that's okay. All right.
Yes.
All right. So the first thing I wanted to comment on, and I'm going to work sort of backwards, which is kind of counterintuitive. I apologize for that, but that's what I'm going to do. First thing, as to the testimony that we heard as to the proposal for, I guess, the retirement parcel for the Bartons. Basically, I believe their kids were going to take, one of the kids was going to take over their home. They were going to build this smaller home on a parcel that they had purchased. We heard testimony that basically the Bartons have been a fantastic steward of the property around the area. Heard from residents who believe that in fact that they kept the property up and were grateful, but we also heard from residents who were in opposition of the proposed development. There had been some testimony or some arguments about the fact that the Bartons had purchased this property at what they believed a discounted rate due to the fact that it was undevelopable at the time. I just want to pull on the record that that's not germane to me, or I think to the board, because it's a factor we don't really take into account, who's making money or not making money, or money to be lost when we're determining these type of issues. So that's something that really had no effect as well. But basically the testimony from what I heard, there's major detrimental effects from this proposed development, the adding of this house. I just wanted to make that clear. Second issue I wanted to address that was brought up by, I believe, Mr. Rosenblatt, is the parameters of this hearing. So this is a special hearing pursuant to 500.7. A special hearing, as it's always been a kind of a unique creature as a tool here in the zoning arena, but it's often been described, and even in the case law, as it's akin to a declaratory judgment. There is an issue or issues to be determined. The person who determines those issues, in my mind, and I believe is clear, is the petitioner. They set the table and set the menu for what is to come before the finder of fact. And I think that is equitable, and that it's a notice issue. This is what we're asking the question to be determined. So this is how we're going to prepare our hearing, and these are the experts and the people that we're going to bring forth in determining that issue. I thought this was important that I even went back to the original petition for special hearing to see what had been requested. And the two things that had been requested was basically what I said at the top of the hearing, to clarify whether or not the restriction under case number 9183 SPH could be removed, and the restriction in sum being basically there's to be no further development of Track A. Of course, Track A is what we're asking now to be developed. And then the secondary issue was, in fact, under BCZR 1A078B4, this statutory, I guess, anomaly per se, to see if it allowed for a home to be built on this parcel. So they're the two issues that I believe this board is focused on in our review. Now, there had been all kinds of discussions concerning the amended FDP process. And I know that during the ALJ hearing that there had been comment on that, and actually part of his decision, he discussed it. In my mind, a request for an amended FDP is a different animal. It's something that takes place either through hearing or through this procedure that has been discussed during the hearing where there's signatures that are gathered. I believe that issue is not before us. Now, that being said, I am sensitive to the fact that Mr. McCann made some good arguments that this statutory requirement of signature had not been properly complied with. I thought it was interesting, we heard from petitioner's expert, how did you determine, which houses were to get signatures from? Because there's, a distance thing and using the map, and the response was, well, the county told us, which is often the case, which is troubling. And I think it's not the fault of the county personnel. They do what has always been done, and often that is sometimes in conflict to statutory requirements. But in any event, I don't believe that issue is before us per se. That's a separate animal. Whether or not that FDP amendment is valid in either way, that's not something that we're looking at here today. So I'm going to turn now to the issues that I think are before us. I'm going to start one with this statute that we had previously noted, that the petitioners argue allows them to build, even though it's RC6 now in the zoning change. We heard heard and read a learned response from Mr. Zimmerman of why this really appears to be a loophole and doesn't make sense. It's not really in keeping with, say, the RC zones. Why are we allowing this to occur? For me, looking at the face of the language of that statute, it's pretty unambiguous. It's basically says you can do it. We looked at when the parcel was recorded. It fits all the prerequisites that are there. I think it was the petitioner's expert had opined that perhaps that this part of the law was placed in because further restrictions were put on other things, and this was sort of a concession type of thing. I don't know if that's true. I don't think I have to know if it's true, but one thing that sways me is that we do have the county comments, exact comments for the requested relief, and I believe there was no opposition, but more importantly, there's no statement that no, you can't build here because this statute doesn't apply to you. So in practice too, from what the county interprets this provision, that the provision allows for one more home to be built. Going to the crux of the matter is, in the prior hearing in 1990, it was, I believe, different zoning, RC4. At that point in time, there was not the ability to build a new structure here. And also, we've heard some testimony about at the time it did not perk. So the most coming back, when I said I was going backwards, we're getting to basically the gateway issue here is whether or not we can even discuss these matters due to the doctrine of res judicata. So it is clear that I believe in the fourth amended FDP that there was a condition that was placed that there was to be no further development of track A. And there and there it is. So, as is often the case and should be the case in zoning situations, when there's a change of law or circumstances, res judicata would not apply. And putting that down to basics, if there is law X and requested relief Y. And if a decision is written that law X precludes development Y, then it doesn't happen. But in the future, if law X is changed or repealed, then res judicata would no longer apply for requested relief. Why? Because there would be a change in law that would allow it to happen. That's the easiest one that you would have. What is less clear sometimes is the circumstances, meaning that there was some sort of tree line or views or historical structure or conditions on the ground that an ALJ or the zoning commissioner felt prohibited the development. In the future, if there's a fire, the trees are gone, the historical structure is gone, that would be definite changes on the ground that would then allow development Y due to the change in circumstance X. So that's the situation that we have there. So when we say the change of facts and circumstances and change of law, it was interesting, and Mr. McCann brought up the fact, I think he even cited a horn book. That was something. And also looking at the Seminary Galleria, is that there's a next step. You can have a change in facts or law, but there's also has to be a nexus between that change and how the original fact finder made their decision in the first place. And basically, if you know you're trying to bring a new case and your argument is, well, I'm allowed to do it now because of global warming. It's hotter now. If the original decision had nothing to do with whether or not it was hot, those circumstances haven't been changed. Those circumstances were not germane to the original decision. So this is where the real heavy mental surgery really takes place to get to the heart of the matter. So interesting thing about the original 1990 opinion was this: when you remove the condition, from the finding, and that's another thing, it's kind of rare that we're doing res judicata on conditions. This isn't even just the opinion, this is a condition. So this makes it even more unique and bizarre in our analysis. But when you remove that condition from the original opinion, if he wouldn't have done that condition, the property still could not have been developed. Under the old zoning, it wouldn't have happened. It just was not there. Um, and then there's the perk issue, which I think is a bit of a canard. I don't think the perk was really in the mindset of the original decision, but it is a change in circumstance now. So if you're thinking back in 1990, what is the purpose of this condition? Well, the purpose of this condition was not to prohibit further development in that case, meaning that he was worried that without that condition, it was going to be developed in the old zoning because it would not have been there. So it's kind of logical to extrapolate that whether or not the zoning permitted an additional unit was not something that was really germane to the condition itself. I mean, the condition seems like to be extra. Um, and that's what it is. It's definitely extra. It's extra. So now we have the change in law that it's RC6. Also have the code section. Is that a change that was germane or a circumstance on which the original opinion was decided? So you have to think to yourself, did the ALJ back then make that condition because of the present zoning? To me, that seems to be absolutely counterintuitive. It doesn't make sense. So as I am confident on my other decisions in my little colloquy here, I am open to being persuaded on this last gateway issue of the actual applicability of res judicata. But I have struggled with this and I have gone back and forth, and that's why I still would like to hear from my colleagues on this. But again, just to clarify for me, when really getting into the logic of it, was that condition placed on there because of the zoning at the time, that there was fear of development because of that zoning. Well, that can't be true because it couldn't have been developed at that time. Um, there's an argument to be said that the condition is there just for this circumstance, that if the zoning ever changed, that they were still protected. I would also like to note that I am not a fan of these conditions whatsoever. To me, it seems to be basically a covenant masquerading as a zoning situation. And as you know, covenants, we can't enforce them. It's for a court of equity, like circuit court, to deal with. But nonetheless, it's been around since 1999 and we have to deal with it. So being intellectually honest, for me, it's tough to say this is a true circumstance that would negate the res judicata. And I know this completely turns the ALJ's decision on its head in reasoning, but it is de novo, and that's basically where I'm coming from at this time. But I can be persuaded otherwise as to my final point. So I am eager to hear from my colleagues. So anyone else would like to take the floor at this time?
Brian, you want to go ahead or you want me?
No, I can. I mean, as usual, Mr. Belt, you did a superb job of summarizing the issues here. And I agree with you. The issue to me comes down to res judicata and whether the change in zoning from 4 to 6, RC 4 to 6 is considered enough of a change. I mean, I've been going back and forth as well. And I think where I fall is that I do agree with you that there has to be some type of nexus. If you couldn't develop the land while it was zoned 4, then why would that condition be put in there? So by changing that condition, I do agree that I don't really see the nexus. And I think that's where I'm falling. And so then the other would come down to the perk issue. And I agree. I think there was, even though it perks now, I think it was still unclear whether it perked then from the testimony. So I actually agree with you, Mr. Bell, and I agree with your reasoning. So that's where I think that's where I am as well.
All right, Mr. Lauer?
Yes, I thought about this pretty extensively and looked at the file. I agree with you completely that in terms of the impact on the community here, that we're not going to have a tremendous impact. I mean, this is a 13-acre parcel. It will, it's larger than many of the other parcels of people that testified against and for. It is only one home that's being added here. I think in terms of legislation and changing the legislation, I read Mr. Zimmerman's comments related to that and the loophole. I think it was clear we don't have to guess what the county council wanted to do. They wanted to change the zoning to R6, and they did. And they wanted to put this, quote, this provision in there allowing the one more retirement home is, I believe, what it's been called. I question, Mr. Chairman, just looking at res judicata and how this applies, and I wonder if the zoning, and I know we're speculating here, at least in some part, I wonder if the zoning had been R6 at the time, if we would have something different. And perhaps, I don't know. It just seems to me that the law has changed, and I agree with both of you regarding the perk and the relevancy of the perk, and it perks now and didn't perk then. I just am also struggling with the res judicata thing, but it was a condition that was in there. I think we clearly have the power to say this condition doesn't apply at this time. And that's That's kind of where I would lean in weighing also into the legislative intent and plain language in the law. I mean, to me, that carries a lot of weight. It's clear that when they rezoned the properties that they wanted to go to R6. And it's clear that they wanted to put this provision in there. And to me, weighing that against this condition that we had from 1990 in a different circumstance is significant. Um, um, and I would think it's clear that that we should follow the R6 and follow the R6 provisions here. It's kind of my thoughts and where I'm going with this thing at this time.
So I am actually, your opinion, I probably had it yesterday. Um, and as I, further extrapolated, the only difference I say here is that two different things. One thing, we're not dealing with the FDP right now, but FDPs to me can have restrictions in excess of zoning.
Yes, I agree.
Because that's something that, conditions, that's, the whole legislative purpose, I believe, for such is that so people know, they know what's going on in the community for purchasers, things of that sort. But we're really not dealing with the FDP issue, so it's not there. But again, also too, there can be conditions pursuant to opinions that are more stringent than zoning as well. So that's why the difference is me. If this opinion had no conditions and the decision says the prohibition is based on the RC4, then absolutely the RC6 change would defeat any arguments of res judicata, because that would be the exact reason why the previous decision was made, because a law clearly prohibited it. And that's why this is so weird, because we're not looking at the decision itself. We're looking at the afterthought restriction that was placed upon it. So we have to go double decker, like not to the opinion, to the decision, but even further as to why is the condition there. And since it's clear that it was prohibited under RC4, there was no need for a condition if the fear was development in RC4. So the need for a condition obviously is that the person who wrote this opinion conditioned that there be no further development. I guess you could say to do that would be, I don't know if they had a crystal ball, to say if, development were the change, they would still believe that there should be no further development. So that's where I am on that one. But I understand your position, Mr. Lauer, because it is at first blush, it was my thought as well. But as I dug deeper and tried to break it down and be intellectually honest to myself, I still fall on the other way. So basically, from what I'm reading, we have a 2-1 on the res judicata issue. Is that our final tally for sure? Are you in keeping with that, Mr. Lauer?
Yes, I would.
Okay, all right. That is no problem. So I am going to suggest, especially since we have a split board, and also that I'm probably confident that another court may look at this. If a court were to agree with you, Mr. Lauer, and it were to be sent back to us, the remaining issue would be the statutory application of the 1A07-8-B-4 that allowed for it. I believe from what I'm hearing from all of us unanimously that we believe, in fact, that though it seems odd for the RC6, it's there, it's unambiguous, and on its face, it allows for this parcel to be developed statutorily. So I just want to make it clear, and we should make it clear in our written opinion, that in the event that our legal finding on the res judicata is determined to be otherwise, that we already have made our determination as to the zoning regulation that allowed for the development. And third, again, I wanted to make sure that everyone else was on board, that I believe that the FDP amendment issue was not within our purview or before us, in keeping with the petitioner's request for special hearing, and is something to be determined by either the county or some other type of process. So again, as I believe I will hearken our deliberation, 2-1 in the applicability of res judicata, in the alternative, 3 unanimously as to the application of the zoning regulation that would allow for the development, but for the prior adjudication in the case number 90-183 SPH. So there we have it. Perhaps another look at this from someone else might tell us that Mr. Lauer is absolutely correct. I can't even tell you that he's absolutely wrong, but in being
Not this
honest,
time, right?
yeah, and in being honest with what I saw through, the Seminary Galleria case with the parking lot delineation, and just using common sense as to what is the legal premise behind res judicata, is that, when law or circumstances that actually affect the decision change, then it doesn't apply. Where I fall short is I'm not convinced that the changes that are being made reflect the reasoning for the original condition in itself. So that's where we are. Without any further ado, do either of you gentlemen have anything more to add before we sign off?
Nothing further, Mr. Chairman.
Nothing further here.
Thank you.
All right, fantastic. Well, I will see, I believe, Mr. Pennington in a while. Mr. Lauer, I'll see you soon, sir.
Okay, very good. Thank you.
Dear Mr. Lauer.
Pennington, Mr. Bell.